all the administration, the faculty, students, and alumni. We welcome each and every one of you to the law school. This is the 11th Annual Symposium on Media Law. And the title of today's symposium is Where Have You Gone, Perry Mason? We will explore the changing image of the lawyer in the media. The topic is especially apropos for John Marshall Law School as we celebrate our centennial, as our country approaches, in the world, in fact, approaches the millennium, and it's an appropriate time to reflect on the role of lawyers and the law in this new era. It's particularly important for us, and we want to welcome you in the vein of our centennial celebration as we can begin it now. The law school was formed in 1899, and we are celebrating our centennial. Our description of the centennial and our foundation is a legacy of opportunity and a lifetime of achievement. 100 years ago, a group of Chicago lawyers shared a vision of legal education. They believed that there existed a need for a school where men and women, compelled to earn their own livelihoods, could get a legal education. That vision created a school of opportunity for women and minorities that would not have had an opportunity to go to law school if not for the vision of the founders of John Marshall. I would greatly now like to, again, welcome you and turn the program over to the symposium director and the chairman of the executive committee of our faculty, Professor Mike Polelli.
Well, as director, I want to welcome you all again for your attendance here. Where Have You Gone, Perry Mason? Evokes idealism, reality, and the image of the lawyer in our society. For many in this audience, the ideal is very clear. It's Perry Mason on television asking a few penetrating questions and the witness crumpling in the witness chair, confessing. Well, prosecutor Berger stands agape-jawed. In fact, when I was in civil litigation, one of my colleagues was very worried that when you picked a jury, you had to let them know that we weren't Perry Masons. The trials were not always very exciting. We were very concerned that we not be held to the high standard of Perry Mason. Now, I suppose the question is whether we have reversed that. But anyway, Perry Mason was the ideal. The reality came home to me a couple of weeks ago when I came across an excerpt from an actual trial reported in the Massachusetts Bar Association Law Journal. And here's the excerpt. Question: Doctor, before you performed the autopsy, did you check for a pulse? Answer: no. Did you check for blood pressure? No. Did you check for breathing? No. So then it is possible that the patient was alive when you began the autopsy. No. How can you be so sure, doctor? Because his brain was sitting on my desk in a jar. But could the patient have still been alive, nevertheless? Well, now that I think about it, it's possible he could have been alive and practicing law somewhere. But those are the painful things that confront every trial lawyer now and then. But there are a few professions that could laugh at itself as well as the law profession. The image of the lawyer came home to me when I was having coffee at a coffee shop, thinking about the conference, actually. And there were two people in their late 20s. The young woman said, "I'm thinking of going to law school." And the young man said, "Most lawyers are jerks." And the woman said, "Isn't that stereotyping?" And the man said, "Well, I didn't say all, I said most." Well, that left me with a number of thoughts. One is, I think the young lady might make an excellent lawyer, questioning the generalizations that our society so easily makes. The young man interested me. What separated jerkhood in his mind? Why were some lawyers jerks and others not? I don't know, but I resisted the temptation to enter into that conversation. But even more importantly, where did he get that idea? Here's a man in his upper 20s, probably has met only a few lawyers in his life, but yet he's already formed an opinion. This conflict between ideal, reality, and public image is one I think that can only be explored by an insider, a true lawyer's lawyer. And fortunately, we are lucky today to have Scott Turow to explain the riddle of the lawyer. Scott Turow has done a lot for the profession. He has proved that lawyers are right-brained as well as left-brained, that they have a prose that can pierce the heart as well as probe the mind, that they are full human beings, flawed though they may be. For many years in American letters, there was no such thing as a lawyer writer or lawyer novelist. Indeed, it was seen by many literary agents as almost a contradiction in terms. Lawyers only wrote legalese. They did not write to the heart, to the emotions. Scott Turow has disproved that and has single-handedly created a whole new genre called the legal thriller. And I know that literary agents are a little dismayed that this thing keeps going on, but it resonates. The public thrills to the legal thriller, and it continues thanks to our speaker today. In fact, whenever I see a lawyer with a briefcase bulging with papers, I wonder whether those are legal briefs or perhaps the opening chapters of a novel. So many imitators has our speaker spawned. Scott Turow wears two hats, as a lawyer and as a writer. He was born in Chicago, graduated Amherst with honors, received a graduate fellowship to the Stanford Creative Writing Center, where he was both a student and a lecturer. And then he received the call. We went to Harvard Law School, graduated in 1978 with honors again. He became an assistant U.S. attorney here in Chicago and specialized in public corruption cases. He was the lead counsel in the Graylord investigations, which I'm sure I do not have to explain to you, which involved corruption in the judiciary and in the official body of Illinois. He is now a partner with the law firm of Sonnenschein, Nath Rosenthal, where he continues to do pro bono work, and he recently secured the reversal of the conviction of Alejandro Hernandez, who was convicted for the murder of Janine Nicarico, and he is currently representing an inmate on death row. As a writer, I even have less to say. His renown is so well known. In 1977, he came upon the scene with 1L, the story of the trials and tribulations of a first-year law student at Harvard Law School. In 1987, Presumed Innocent burst upon the scene, a national bestseller and successful film. 1990, his first book was followed by Burden of Proof, again, a major bestseller, and the image of Scott Turow landed on Time magazine. He had arrived. His third book, Pleading Guilty, was published in 1993, and his last book, Laws of Our Fathers, published in 1996, deals with the contemporary murder trial of individuals who first met in the age of Aquarius. I understand that he now has a book that he's working on, Personal Injuries, which is due sometime next year. And there's nothing a writer likes to hear than a deadline to send chills, I imagine, down a writer's spine. But in any event, I think we all look forward to this new book. The 1L book is under negotiation now for a possible TV series this upcoming year. So please consult your television guide in the near future. Scott?
I'm listening to Michael's recounting of that famous, and I don't know if it's an apocryphal deposition story or not. I was reminded of one that I've stolen for this new novel of mine, in which a lawyer is instructing a witness, and witness is very tense, and it gives him the usual, listen to the question. If you don't understand the question, tell me you don't understand the question. All your answers to questions must be oral. State your name, oral. So Michael's comments, interestingly, foreshadowed much of what I'm going to be talking about. So I appreciate the sort of ramp up that he's given me. I don't know how many of you have seen the latest Woody Allen movie, the one that's now out on video, Deconstructing Harry. But it's about a writer who uses his friends and family quite liberally in his fictions over the years. And needless to mention, some of my friends and family took me to see it. But the scene that I found most enjoyable or amusing, imaginative, was the one where Harry Block, the writer, goes down to hell. And he takes an elevator, and on his way down, it's like the department store, the oldest department store, where they announce what's on each floor. But in each floor now, it's the the doomed cells, the doomed souls who are described. And about 3/4 of the way down, about the 7th level of hell, Harry reaches a floor whose occupants are described as something like child molesters, encyclopedia salesmen, and lawyers who appear on television. And as a lawyer who appears on television now and then, I cringed somewhat. But I think all lawyers could, as Michael's introduction suggested. We remain still the butt of the ubiquitous lawyer jokes. How do you know that God was a lawyer? Answer, because he created chaos and darkness first. Why are lawyers like rhinoceroses? Answer, because they are thick-skinned, short-sighted, and always ready to charge. Why do recent surveys indicate that almost half of all lawyers in large law firms live to be 100? Answer, because the surveys are based on their timesheets. But on the other hand, if Americans, like the 20-some-year-old gentleman that Professor Palleli mentioned, if they really hate lawyers so much, why are there so many lawyers on television? As Michael mentions, the only lawyer on TV during the era when we were growing up was Perry Mason. He was good, pure, virtuous, and just like his clients, who were also good, pure, and virtuous and misunderstood. And Perry, of course, was always a victor. Now, of course, lawyers are everywhere throughout the popular media, and that's really what brings me here. The so-called legal thriller has become the single best-selling category of books in the country. It's maintained that role for a while, although the sales peak, I think, is behind us, and I'll talk about that a little bit later. But in addition to the juggernaut of John Grisham and myself behind him, there are people like Richard North Patterson or Steve Martini or David Baldacci, who also sell hundreds of thousands of books each time they publish. The list is really pretty impressive. And again, as Michael mentions, there are always thousands of contenders in the wings. I have appeared occasionally at a course offered in the University of Chicago Law School on fiction writing. It is given in the law school, was taught for many years by Norval Morris. And of course, I hear on a routine basis, several times each week, from lawyers around the country who think they've got a novel in them and want me to read it first. And I've even had this happen with more than one of my partners, several of them in candor. And you know, who's to say these folks will not be the next John Grisham? I have seen more than a couple of names that have started out in my own personal slush pile arrive on bookstore shelves. So it will happen. Although I'm not going to bet much on one lawyer from Miami who called me up, very aggressive fellow, and he's now Scott Turow, yes. I have to ask you something. I'm going to write a novel. I said, well, I don't listen to other people's plots. Lawyers have told me I'm just going to get myself in trouble. No, it's not that. And I said, well, I don't give writing tips over the phone. I'm, really not interested in that. No, it's not. That's not that I need. I haven't written this book yet. I said, well, that means I don't have to read it. No, he says, I just need to know one thing. when I'm done with it, how do I sell the movie rights? And anyway, the phenomenon, obviously, of the prominence of lawyers as the subjects of narrative is not isolated to the world of books. L.A. Law was obviously the #1 rated show on television for years during the 80s. Law and Order continues as the longest-running drama on network television. Ally McBeal was last season's hot new series, along with The Practice, both of them written by lawyer David Kelly. We know what the movies have given us, a steady stream of box office hits with lawyers at their center. And of course, the interest in lawyers and the law extends beyond the world of the fictional. Indeed, the real world has given us court TV and the mega hits of the courtroom. I think the Simpson case remains the sort of Gone with the Wind of legal television. But obviously, I, like millions of Americans, was watching Kenneth Starr yesterday, and we really, it turns out, by now have become a nation of court buffs. There are cab drivers and grandmothers who can tell you whether or not a cross-examination was effective. I used to worry in writing that when I used a term like sidebar, but now I know that virtually everybody knows what a sidebar is, and it's even begun in the wake of the Simpson trial creeping into the common vocabulary, and people will go, well, let me give you the sidebar on that. And if you think about it, we really have had the so-called trial of the century about once a year for the last decade. We've obviously had the president's troubles most recently, and the Simpson case, but we had Lorena Bobbitt, we had the Menendezes, remember poor William Kennedy Smith. We've obviously had Tim McVeigh and Terry Nichols in the last 18 months, and poor old Ted Kaczynski. And all of them have been dragged into the high-beam media spotlight and have proved to be of great interest to the American public. So the question is, what goes to explain this consuming American interest in the law? And why has the image of lawyers changed so radically since my childhood, when Perry Mason ruled the book racks and the airwaves virtually alone? And why are Americans so interested in lawyers at the same time that they hold lawyers in the kind of scorn and contempt that the lawyer jokes suggest? How could it possibly be, to be most direct, that the lives of attorneys, which actual practitioners often find somewhat like cops, varying between the direly stressful and the terribly dull, how can those lives have become one of America's principal forms of entertainment? Now, I pose these questions to you because they are essentially posed almost incessantly to me. I am frequently accused, so to speak, much as Michael did today, of having created or invented the so-called legal thriller with the publication of Presumed Innocent in 1987. And having supposedly started this trend, I am often asked to explain it. And after several years of just shrugging it off, I actually found myself beginning to contemplate an answer. And my remarks to you today are really a product of that process of deliberation. Let me say, though, I take a couple of things for granted at the outset. One is I reject the default theory, which I've sometimes heard bandied about, and this is that, well, there's really nobody left to be interested in. Spies are out of business. Cowboys with their gunfights and wars against the Indians are no longer politically correct. Private detectives, if they ever existed, have now gone the way of the dodo bird. So who else is left? We just have to look at lawyers. Obviously, I think that sells popular culture much too short. Each of those hero types that we talked about, that I talked about it before, are widely viewed by popular culture dons as having tapped into some kind of relatively profound cultural yearning, and usually some kind of deep-seated ambivalence. The cowboy who emerged as a hero particularly in the early part of this century, as America was going through a process of urbanization, obviously represented the regressive yearnings, much like the creation of the Boy Scouts, by the way, to get back to the land, to leave the urban landscape, even though the cowboy tale almost always reveals the need to return to town and the civilizing influence, as it happens in those stereotyped days, of law and women folk. That's who are in town, and that's where the cowboy ends up having to go back to. The spy figure, at his best in Le Carré or Graham Greene, was the lonely individual caught up in the world of ideology and bureaucracy, who discovered in attempting to serve patriotically that there was emptiness in the large public truths of both capitalism and communism. So the question then is, what does the prominence of lawyers today in the popular imagination imply? Again, given the examples of the spy or the cowboy, it seems to me that there is a profound ambivalence at hand. Again, lawyer jokes on one hand, the whole nation at standstill for the Simpson verdict. So Americans are awestruck by the power and influence of the law, and at the same time they find so much about attorneys to hate. Now, I refer to this phenomenon as the Madonna complex. And what I mean by that is that there are certain figures that emerge, very often enormously popular ones, that are able to capture a kind of terrible conflict or ambivalence. In Madonna, the great example, because people look at her, or at least they used to, and go, she's so hot, she's so cool, she's so gross, God, I can't stand her. Dennis Rodman's another example. The Beatles, when they first appeared, were, again, boy, that music is great, I can't stand the way they wear their hair. And Elvis with his gyrations. All of these figures managed to tap into some kind of deep ambivalence in the culture. And it turns out that very often is the nature of popularity, its ability to embody raging and contradictory impulses. So I want to return to the emerging prominence of the legal thriller, and use it to illustrate a number of points that I think go to answer the questions that I've been posing. First of all, Michael, I've got to set the record straight. I didn't invent the legal thriller. For one thing, I completely lacked intent, as we would say, in the law. Dom Perignon supposedly invented champagne by accident, but at least when he tasted it, he knew enough to say, I'm drinking stars. I really never had a clue about the profound interest in dramatizations about the law. I wrote Presumed Innocent largely in reaction to certain views of the novel that had been passed on to me during my many years out at Stanford at the Creative Writing Center, and also because it was the milieu that I was in. I was an assistant U.S. attorney at that point, and I was interested in the criminal law and passionate about it. And the fact of the matter is that this is nothing more than a representation of the old saw of writing about what you know. And even with that, of course, it required luck and circumstance for Presumed Innocent to happen. I was on trial in January of 1986, trying Reginald Holzer, who was one of the Greylord judges, in a case that had attracted a great deal of prominence because Holzer, unlike the judges who were engaged in sort of routine hanky-panky with smaller criminal cases, Holzer, who was sitting in the Chancery Division, of the Circuit Court of Cook County dealt with what seemed to be boxcar figures. He'd approach lawyers for loans that very often went unrepaid, and these figures were $5,000, $10,000, $15,000. There was, by the time we got done counting, more than $250,000 that had come the judge's way. And as this sort of satisfied the media stereotype of what a corrupt judge must be doing. Much better to see a judge selling himself for $10,000 than $250,000. And so there was intense interest in the case. The more the interest grew, the more frightened I became, of course, about losing it. I stopped sleeping. My wife, as a result, stopped sleeping, and she therefore turned to me early one morning in the winter of 1986 and spoke to me the words that I think are familiar to the spouses of lawyers everywhere, namely, "I want you to quit that goddamn job." And she proposed that I finish the novel that I had been dragging around in my briefcase at that point for about 6 years. And I did with absolutely no intimation of what lay ahead. At the time I finished Presumed Innocent, at least a draft of it, I had a choice. I'd taken a summer away from the law at Annette's urging, and he had a couple of weeks left on this magical summer without practicing, and I could have done two things. I could have worked on the novel a little bit more, but I figured it would go the fate of many of the things that I had written before, or I could paint the porch. And I painted the porch, so I didn't have a clue what was coming. I did not, with Presumed Innocent, discover some new source for literary themes. The law has always provided the setting for important literary works, The Trial of Socrates or The Merchant of Venice, Dickens, who of course had worked around lawyers and in their chambers, and Melville, the son-in-law of Lemuel Shaw, the great Chief Justice of the Massachusetts Supreme Judicial Court. Both had deep exposure to the law, both wrote about the law and legal situations with profound insight. And in the realm of popular fiction in my own lifetime, Presumed Innocent was not the first #1 bestseller about a trial. Both Anatomy of a Murder, written by an appellate court judge in Michigan, and To Kill a Mockingbird, still a staple on high school reading lists, had both been great literary triumphs during my childhood. And yet there is, I think, something or a few factors that distinguished the law-related novels and stories that went before. And there are, I think there are three things, and I want to talk about these because I think they are all revealing of what these cultural ambivalences that I was talking about may be. One is the level of technical detail that all of these books contain. The second is the conception of the hero. And the third is the time period when all of these narratives about lawyers began to appear, which is namely the 1980s. Now, let me talk about the technical interest. I wrote in self-conscious reaction to what had gone before. I hated Perry Mason. I hated it as a kid because I knew even as a child it couldn't be that things happened that way in a courtroom. And of course, it got even worse when I went to law school. And so one of the points of pride is that no matter what the other contrivances might be in my novels, the law I try to make pretty accurate. Certainly the evidentiary rulings of Laren Little in Presumed Innocent were arguably correct. A few of them have wandered into criminal procedure case books where they're debated, but arguably they were correct positions on the law. And Sandy Stern's questions and his objections were, I thought, proper and sound. Now, I thought, frankly, I was going to bore the living hell out of my readers, but it satisfied me. I was writing in my basement, so what difference did it make? It probably wasn't going to get out of there. Instead, when Presumed Innocent was published, it turned out that the 190 pages of the trial scenes turned out to be the favorite part, well, maybe the second favorite part in the book. And all of the works that have followed have reflected this greatly intensified emphasis on legal procedure and the nuts and bolts of a lawyer's life, what goes on in the office. How do lawyers think? How do they talk? What are the rules? And it's a far more detailed portrait than was offered even in a popular book of an earlier generation by one of the very few lawyer writers, authentic lawyer writers who existed 30 years ago, Louis Auchincloss. Now, so why are Americans so intent on learning the details of what we do? And I think the answer is pretty simple. The law now intrudes into the lives of average citizens in manifold ways that it did not a few decades ago. The average citizen is simply exposed to the law much more often. It's hard to document these things, but there was a survey done in late 1993 and published in the National Law Journal that found steady growth in the number of Americans who reported having had contact with attorneys in the last 5 years. That's not surprising because the society at this point seems to be awash in litigation. There's the so-called torts explosion, which I'm sometimes faulted by friends who do plaintiffs' work for referring to as the tort explosion. They regard this as the rights explosion, that people have rights of redress that they did not have many years before. But no matter how you view it, the fact of the matter is that it has dramatically shifted the power relations in a number of contemporary relationships. Even your parish priest is now subject to lawsuit. Unthinkable 30 years ago. When my father was a doctor. Nobody sued doctors when I was a kid. To say the least, that has changed. I cannot go swim at the high school swimming pool where I live, which people used to do when I was younger. Why? Well, the lawyers say you can't do it. And of course, it's because I am not within the coverage of the high school's insurance policy. And people blame us for this state of affairs. They blame us for the fact that most sophisticated employers will no longer give references, even for their best employees. The logic being that their failure to give a reference then for a bad employee will be read as a negative comment and lead to a defamation suit. And the fact of the matter is that all of this stuff has changed the kinds of environment in which we all live in a day-to-day world. I was astonished when I went to work at Sun and Shine that there were no longer such a thing as dirty jokes being told in the hallways, something that I'd always lived for in the U.S. Attorney's Office. And people explained to me the sophisticated concept of a hostile environment, and my law firm has always been particularly committed to being a welcoming place for female attorneys, and there was no, and there never has been, any off-color stories, much as I miss them. So the power relations have been shifted by the law, and people see it all around them. They also see, of course, attorneys becoming necessary appendages in places that they never imagined them being. A lot of folks can't deal with their health insurers these days without involving a lawyer. It was amusing to me that when Latrell Sprewell choked P.J. Carlissimo, the person who held the conference the next day was Sprewell's attorney. At this point, 57% of Americans say lawyers have too much influence in the society, and it's not hard to figure out why they feel that, because lawyers are really just about everywhere. Both of the agents who represent me at in the Hollywood colossus of CAA, Creative Artists Agency, are both graduate attorneys. Pat Robertson, the famous TV evangelist, is a graduate of the Yale Law School. Jack Fuller, who's the president of the Tribune, and countless other CEOs have legal educations. And so people have this sense that the legal sea is invading. Americans see the law as simply having overwhelmed its boundaries. Now, when I was a graduate student out at Stanford, there was a very famous professor of English. He had done something that it's hard to do in the world of English. He had discovered something, or actually rediscovered something, and his name was Ian Watt, and he had discovered the 18th century novel. And he'd written a still classic of the novel, and the thesis of the book was that the novel had come into being as an educational instrument, that it had taught people in the 18th century, as the Industrial Revolution began, as women no longer had to work and could remove themselves from the workplace, be at home with their kids, and begin to live a genteel life. It taught those people, the women in particular, how the upper classes behaved. And so these novels, so-called novels of manners, literally were novels of manners. They were like an etiquette book. And although people learn best through stories, something that every trial lawyer, I think, has learned along the way, there really was an educational purpose at hand. And the fact, of course, is that that's what's driving, I think, first and foremost, the interest in legal fiction. People want to know about and understand, they want to be educated about this force that is so much more dominating in their lives than it was. Okay, so that's point one. That's why I think there is this concentration on technical detail in all of these works. Second, as I said, was the image of the hero that emerges in these books, that is, the lawyer who emerges. Here this is a really interesting contrast, because the negativity that's suggested in the lawyer jokes does make its way into the way that lawyers are portrayed. Perry Mason, with all due respect to Errol Stanley Garner, was kind of a pasteboard. But if we look at Atticus Finch, the hero of To Kill a Mockingbird, a much more round and compelling character, he's still the epitome of a kind of Lincoln-esque virtue. He's defending for free an African-American man who's accused of raping a young white woman in a small southern town during the absolute heyday of Jim Crow and American racism. And Atticus Finch, generally speaking, with not many exceptions, is a flawless human being, just like Perry Mason. Lawyers clearly were, either in sophisticated or the most commercial renderings, people to be greatly admired. Now compare that, of course, to the portrayals that emerge now. Rusty Sabich, the hero of Presumed Innocent, had deep problems that arose from a compulsive extramarital affair. He was an adulterer. He was, actually, if you were beguiled and misled by his narrative, it turned out somebody who could use the truth quite conveniently. The hero of The Firm, John Grisham's breakthrough book, as they say in New York, was also unfaithful, and more to his damnation, guilelessly but completely greedy. So the lawyers who are represented now in these popular fictions are not sentimental heroes. They have impulses they can't control. They have made a robust selection from the menu of deadly sins. And of course, as I say, that's in line with the less lofty view that Americans hold of us. Now, hating lawyers is, of course, that's not a recent development. According to Luke, Jesus remarked, "Woe unto you, lawyers." But certainly hatred of lawyers has a special primacy today. And I think basically what's happened is that Americans have discovered that we are a lot less adorable than we used to make people think we were. I remember I made most of my career as an assistant United States attorney prosecuting lawyers. I began as the junior lawyer in the prosecution of William J. Scott, then the Attorney General of this state. I moved on to the investigation of corruption at the Cook County Board of Appeals and prosecuted the lawyers who were bribing the hearing officers there, and then I finally rolled over into Gaylord. And when I was beginning that, a prominent Chicago defense lawyer came to my office. He closed the door. He said, what the hell are you doing? said, I was the chief of the criminal division in the state's attorney's office. When somebody came to us with an allegation against a lawyer, we went to the lawyer and we said, cut it out. And we left him alone. You can't put lawyers in jail. But of course, the American bubble had burst, and it burst with Watergate, which involved the discovery that about 3/4 of the people who surrounded the President of the United States were attorneys, and all of them felons. It sounds amusing, but it's painfully true. The Attorney General of the United States, John Mitchell, went to the penitentiary, as did John Ehrlichman, the counsel to the President, and John Dean, another counsel to the President. And as a result, we ended up with legal ethics courses introduced into the curricula of American law schools, not to deal so much with a clamor from the bar as from the American public to do something about these rascals that were coming out of the doors of legal institutions all over the country. Now, I have to say that my own perspective on this is that lawyers are neither any better nor any worse than any other segment of this society. There is law breaking among all groups in the society. There is a lot of law breaking among attorneys, but there's also a lot of very admirable conduct. And to the extent we are the victims of the sort of lofty expectations that went into the Perry Mason, Atticus Finch era. But beyond not liking the fact that lawyers break the law, Americans often don't like the answers that the law provides. The more they see of the law, the more uncomfortable they are with the legal process. The law answers hard questions. A casual acquaintance and a fine judge, Joe Turow, in Boston, it's his custom to say that this is a very hard job because even on a good day, 50% of the people in my courtroom leave unhappy. And the law wrestles with difficult problems, and because we have to declare the rule of law, something that we can go forward with, the law has a very difficult time doing what's done in the average law school classroom. Your professors will say, well, here are the two arguments, could be this way, could be that way, majority view, minority view. Not when you get to the courtroom. The law is declared with finality and with certainty, and the ambiguousness of the problem cannot be formally acknowledged in the law. And Americans subjected to that feel an understandable difficulty with it. And of course, there is advocacy, which has always been seen as disingenuous. The nature of the adversary system is simply that way. Thoreau complained that the lawyer's truth is not truth with a capital T, but consistency or a consistent expediency. But those are that's sort of an age-old complaint. But all of this ignores what is generally found to be the number one complaint that Americans have about lawyers. Answer, they make too much money. Legal earnings have far outpaced inflation. And 43% of Americans in the most recent survey I can find, again going back to late 1983, said that lawyers charge too much. And that, I think, is frankly what's probably in the front of the brain of this young man who attacked attorneys. Lawyers have moved far more uniformly than any other professional group into the upper class. And it comes at the same time that doctors' incomes, the other sort of competing professional elite, have gone down or have been stabilized, and doctors as a group have sort of taken on water, and lawyers, somewhat at the expense of the medical profession, at least in their view, have continued to move up the income charts and to march much more, to a much greater extent, into the not just the upper middle class, but even the upper classes. in terms of their income. By 1995, the average income of a law firm partner in this country was over $200,000, and it's clearly more than that today. And so this kind of hooks together with the last point I wanted to make about the rise of the so-called legal thriller, and that is the time when it began to emerge, which is the 1980s. Now, I use that term, the 80s, much as I used the term the 60s with reference to my last novel. The 60s really ended in 1972 when Richard Nixon was reelected, and the 80s really ended in 1992 when George Bush was defeated. But I think that this era of Republican reign will come to be seen historically as a sort of relatively continuous period in terms of the national values, sometimes referred to as the me decade, but it brought us these law-related narratives for the first time. Presumed Innocent was published in 1987. L.A. Law by then was as I say, a #1 hit on television. Court TV was conceived of during that period. So what was going on then? What drove this? Now, here I get relatively speculative, but I see that period as a time when various free market economists and intellectuals really began to take hold of national policy. Those of us in the room, many will probably remember the so-called Laffer curve. Now, my own attitude toward free market thinking has always been something wicked this way comes, but whether you share my views or worship at the utilitarian altar, it's clear that those years gave us a much more positive view of economic activity than we had had, especially among the educated classes in this country, over the preceding 30 or 40 years. The intense kind of communitarianism of the middle part of the century, which was expressed in things like the New Deal or the Great Society or the sort of love each other ideologies of the age of Aquarius, the claim of liberalism that government was entitled to restrain and rechannel individual appetites for the benefit of the community as a whole, and certainly for have-nots in particular. The 80s view was that that all had been debunked. Rational policy started with the market. The market was what was good for America, and market concepts began to penetrate all kinds of unlikely places. I'm a great detractor of Buckley versus Vallejo, which equated the right to spend to the right to speak, and is the huge impediment to restraining the amount of money that gets spent in political campaigns, because the right to spend is considered to be protected by the First Amendment. Making money during that period suddenly became a good thing again, quote unquote. A friend of mine, Jim Atlas, wrote an article in the New Yorker that had a lot of commentary last year called "The Whistle of Money," and he reported that he'd been horrified to find that having money was now cool and he didn't have enough. It wasn't disreputable as he believed in the 1960s, and Americans had embraced money in the market and what money buys. We now, come the 80s, find out that mall shopping is the leading American hobby, and everybody got into the commercial swing. Institutions that were supposedly too high-toned and sophisticated to be grasping and commercial, like museums, got involved in advertising. They were selling T-shirts with King Tut or Monet on them during that period. Now, what I think the legal thriller reveals is that Americans are much less at ease with this state of affairs than the ringing cash registers might suggest. Now, again, I am peddling the notion of ambivalence, not rejection. I'm not saying that Americans are rejecting mammonism. It's clear that they're not. What I'm saying is that the novel embodies certain doubts they have about the costs of free market thinking. Because it turns out that the temptations of money is probably the most prominent theme in the legal fictions. John Grisham's lawyers, the bad guys are always the people who have succumbed to the temptations of money. Always. And I am not immune from similar portrayals myself. My hero, Mac Malloy, in Pleading Guilty, is somebody who is dealing at all times with the temptations represented by money. Now, this is certainly not limited to the world of books. I met Marshall Goldberg, one of the creators of L.A. Law, about a year and a half ago, and he said rather emphatically, we were speaking on the same panel, he said, L.A. Law was not a lawyer show. It was a greed show. But the fact of the matter was it was both. It offered lawyers as the pivotal figures in the Great Me decade, and they were gripped by greed and ambition. But, of course, they were also capable of virtue. And that, I think, the contemporary lawyers, these heroes in these fictions, still share that with Perry Mason. They are seen as struggling to do good. And even though Americans are suspicious of lawyers, even though they really hate the wealth of attorneys, and are not very satisfied with the power that they deploy throughout the society, they continue to recognize, I believe, a positive potential in the law. They see the law as having changed the society, often for the better. I use the example of the working woman who was touched offensively by her boss 50 years ago. Where did she go? Well, what happens as compared to what happens today? 50 years ago, she might have gone to her priest or perhaps her husband, who would have employed violence, or she might have made some other kind of appeal to community sentiment if she had the courage to even speak about this. But now she goes to court, and she goes not because she wants public discussion of these incidents, but because it's the most reliable place for her. It's the one place where she knows she's going to get an earnest hearing and the best redress for the grievances that she's got. And she goes because she is saying, in essence, the law is more effective than any other institution, than my marriage, than my religion, than my community, in calming my outrage and doing something about this situation. And this, too, I think, contributes to this intense interest in lawyers. I think our procedural rules in the legal profession, for example, look pretty good compared to the procedural rules that are employed in many other professions. Ask the average American, no matter what the lawyer jokes, who do you think would treat you more fairly, a judge in a court or a journalist? And see what answers you get. People may grouse, but they still have the sense that there is a culture of fairness that operates in the law. And certainly I can tell you my experiences in the literary and the academic world and the securities industry, where I did a lot of litigation over the years, or the world of Hollywood, the legal world runs more fairly than any of those other sectors of this society. And the law has come in the last 30 years to fill a certain vacuum that's been created in some ways by the nationalization of our marketplaces. Years ago, when I was growing up, as I never thought I would be here to say, the 50s, when I grew up, was the time when father knew best. It was a sort of the melting pot, a monolithic society. And now we've got this view of a diverse, pluralistic society where no one segment of the society has values that can be preeminent. That's the point of diversity. Now, that has had a lot of cost in terms of the authority of what I refer to as local spheres of value. the kind of things I was talking about in the example of the woman who was sexually harassed in the workplace. Church, school, local community, although they remain important staples and supports for people in their spiritual and personal lives, and their importance is not diminished in any way, but they can't speak authoritatively to the overarching questions of values that exist in the society. And it turns out to be that it is to the courthouse that people go again and again to deal with these intense issues of values, of social values that plague the society, and of course always will. It's the courts. It's the courts now. Not churches, not schools, not marriages, not local communities that deal with issues like abortion, surrogate motherhood, euthanasia, who ought to take care of baby Richard, or what is sure to be the cutting-edge issue of the late 90s and the early aughts, whether gay people should be allowed to marry under law. Now, some people talk about the law. The same cadre out of the University of Chicago has had great influence in seeing the law as a economic engine, something that embodies the sort of utilitarian calculus of what's greatest good for the greatest number. But I've always felt that when you get to my neck of the woods, the criminal law, that frankly, there is no economic rationality. You cannot see in the law simply an economic engine at work. There is no economic rationality to the death penalty. Its costs are staggering. Its deterrent value, which there's probably a little bit that can be documented, but it's minimal. And certainly the deterrent value of the death penalty is, if you want to talk about correlation with murder rates, take a look at the unemployment rate. There's a real correlation, not with the presence or absence of the death penalty. And we have side-by-side comparisons going on in this country because some states have the death penalty and some states don't. But people, an overwhelming majority of Americans, favor the death penalty. They want vengeance. They want to know that their own values are more secure, and they feel they are when there is a death penalty as opposed to a natural life sentence. They want to know that ultimate evil has an ultimate cost, and that's a judgment value. I similarly think that you can't rationalize the war on drugs economically. We spend more than $30 billion every year locking up people for narcotics offenses. And you can think about what that $30 billion would do if it was spent on education. But the fact of the matter is that the use of drugs is a scourge. We've all seen it destroy lives. It happens that the young are particularly vulnerable, and every parent has the same nightmare. And so we spend. May not be rational, but a parent, of course, will do everything and anything to protect his or her children. So the marketplace, I don't think, really rationalizes everything that the law does. It doesn't work to say that you just add up the sum of individual preferences and you get what's good. And I don't think that's what the law does. I don't think that that's why we have a death penalty. I think it's an attempt to answer, whether I agree with it or not, to provide an answer to the horribly difficult question of how do you address ultimate evil? And the law provides an answer. And I think that is what Americans are looking for in the law, ultimately. A notion of a justice that is larger than simply dollars and cents. And I think that the law, for better or for worse, with whatever stumbling, has been trying to provide it. So in the end, the American people, I think, look at us in terms of their popular imagery, and a reviled, grasping, self-aggrandizing group. But we are also, through the work we do every day, the group who tells Americans, in the end, what is worth believing in. And I can only say that, I can only hope that that faith is well placed and does not prove over time to be one more legal fiction. Thank you.
I want to thank you, Scott, for a truly inspiring presentation here of the dilemma faced by the lawyer. And as a symbol of our gratitude, I'd like to present you with the famous John Marshall bag. Only an honorarium, filled with John Marshall Law School memorabilia. I certainly want to thank my colleague and Chicago Bar Association President Leonard Schrager, without whose help we would not have Scott here today. Gary Watson, who organized the conference, Marilyn Thomas, Michelle Graham, who did the publicity, and Sophia Rodriguez, who was in the trenches putting up the posters and the signs. We are having a reception right afterwards on the third floor. You can take the elevator straight down. Due to the delightful problem of such a large crowd and the limited time of our speaker, however, we ask that you not solicit autographs, but you are permitted to say hello. You'll be happy to know. So thank you all for proving once again that law and literature lives in Chicago.